Your motion to sever, and again, a bill of exception, make no sense at all, because like I said, you don't know what you're doing in practicing law. You're not a lawyer. You have no idea what you're doing, and your motions don't make any sense whatsoever. So that one is also denied. This is a hearing on a number of motions from the respondent mother in cause number DC 2025 FM 1824 in the interest of the Williams boys. Let me have the parties identified.
Leah Ann Kidd, representing the department. With me today are permanency specialist Paige Harmon and supervisor Heather LaQuay. We're present. We are ready.
Sarah Moore, appointed attorney for mother. Jade Gorham.
Jim Shaw, representing the father.
Matt Moore, representing the children, present ready.
And Jade Gorham, I'll be representing myself.
And Joanna Belford with CASA.
Okay. Ms. Gorham, I looked through the file to see what motions you had pending. The last time that we were here, you were here in person, and you had decided at that point, you really turned a corner in the case, I thought, and decided to start listening to your attorney and paying attention to her legal advice and start services in this case to try to get your boys back. Soon thereafter, you filed a whole bunch of pro se pleadings that make absolutely no sense whatsoever, because you don't know what you're doing when it comes to practicing law.
Understood. Yes, Your Honor.
So the motions that you have on file that cite the rules of appellate procedure, for example, your bill of exception under the rules of appellate procedure, we haven't even had a final hearing in this case. So motions under the rules of appellate procedure, like a bill of exception, again, make no sense, and that one is denied. Your motion to sever, and again, a bill of exception, make no sense at all, because like I said, you don't know what you're doing in practicing law. You're not a lawyer. You have no idea what you're doing, and your motions don't make any sense whatsoever. So that one is also denied. Your motion to take judicial notice of adjudicative facts, that doesn't make any sense. We haven't even started the final hearing yet. So that's denied. Your objection to the associate judge at this point is late. That is denied. But even if it weren't denied, the final hearing in this case is going to be in front of Judge Eichmann. So again, that one doesn't make any sense. Your motion for summary judgment. A motion for summary judgment in a family law case, particularly a CPS case, where the judge has to decide issues of disputed facts. And even in your own pleadings, you talk ad nauseum about all the facts that you dispute in this case. So you even admit in your pleadings that we have disputed fact issues in this case. So again, your motion for summary judgment doesn't make any sense. You have an objection to a permanency report and a request for an evidentiary hearing. We have an evidentiary hearing coming up. You have a final hearing set in front of Judge Eichmann. Ms. Kidd, when is that set?
It's set for September 1st, Judge, and we have a 3 to 4 day span of dates in front of Judge Eichmann.
Okay. So I guess that one is granted. You have an evidentiary hearing coming up September the 1st, and you will be given the opportunity at that time to object in whatever way you want to the permanency report. You're going to have an opportunity to testify, and you can say whatever you want to about the permanency report. So I guess that particular motion is granted. You already have an evidentiary hearing set, and you will be allowed to object to the permanency report at that time.
Can I address the court, Your Honor?
Yes.
The 14th Amendment of the United States Constitution and landmark rulings by the Supreme Court of Texas state that I hold a fundamental liberty interest in the care, custody, and management of my sons.
Agreed.
The law mandates a strict constitutional presumption that my choices and directives as their mother are what is best for them.
Agreed.
The Department of Family Protective Services does not have the legal authority to substitute its judgment for mine and disrupt my family based on speculation, caseworkers' opinions, presumptive drug screens, and flawed administrative paperwork. It is because of court-appointed attorney Sarah Moore's refusal to mount a defense and advocate for my liberty interests, which are irrevocably in the best interest of my sons, that the department has completely blindfolded the court, silenced the truth, and tainted the record. Therefore, pursuant to Article 1, Section 10 of the Texas Constitution, I request for substitution of counsel immediately. As the court has noted, I am not an attorney and I make no claim to be one. I
Ms.
stand on the
Gorham?
fact that I am not a risk to my sons.
Ms. Gorham?
If the Department of Family
Ms.
Protective
Gorham,
Services
stop.
wishes to continue its presumptions, I
Ms. Gorham, stop. I muted you, so it doesn't make any sense for you to keep talking anyway. Your motion to substitute counsel will be granted as soon as you hire your own attorney. Okay, unmute yourself and go ahead.
As the court has noted, I'm not an attorney and make no claim to be one. I stand on the fact that I'm not a risk to my sons. If the Department of Family and Protective Services wishes to continue its presumptions, I require a truthful narrative. If I am a risk to my sons, the U.S. Constitution requires that it be proven, not presumed or fabricated. If we can all just look at the list of exhibits, I'd like to point out a couple, if I may.
Ms. Gorham, your exhibits have not been ruled to be admissible, so I am not going to look at your exhibits. Again, you don't know what you're doing in trying to practice law, Ms. Gorham. And you're trying way too hard to be a lawyer in this case, and you're trying way too less to get your sons back. I've been saying this since September of last year, that you spend more time trying to be an attorney in this case than you are trying to get your sons back. It's very unfortunate.
A call to my mother from my mother on 9 was
Ma'am, you can't testify unless you're under oath. You can't tell me facts of the case unless we have witnesses here to talk about it, and it's not hearsay. This is all evidentiary stuff.
It's in there.
Ma'am, don't argue with me. You're trying to practice law again, and you're not doing a very good job of it, ma'am. Would you like to call a witness? Would you like to call a witness?
The Department of Family Protective Services is everything that I have pulled from my exhibit.
I can't hear you. You're cutting in and out. I can't hear you. Is it just me, or is anybody else having trouble hearing her?
Yeah,
It's clipping for me too, Judge.
Ms. Gorham, who would you like to call? We got Heather LeQuay and Paige Harmon here from the department. Are you wanting to call one of them as a witness?
Yes.
Okay, and tell me which motion we're hearing right now. Which one of your motions what are you asking the court to do?
I can't hear you.
This meeting is
Okay,
being
Ms. Gorham,
recorded.
can you hear us now?
Yes, I can.
Okay, I'm going to call your first. Well, first of all, tell me what motion, what are you asking the court to do?
I'm asking the court I would like to call the department as my first witness, as all of my exhibits are taken from their 968 pages of case notes, case reports.
Okay, Ms. Gorham, this is not your final hearing. You have a final
Understood.
in this case set September the 1st. So tell me what specific motion you're wanting the court to hear right now.
Motion to vacate. It's my combined motion to vacate and for summary judgment.
Ms. Gorham, your motion for summary judgment is denied because there are factual issues to be decided by the court in this case. A motion for summary judgment is extremely inappropriate for a hearing like this, for a case like this. Your motion for summary judgment is denied. I'll take up the motion to vacate.
I'm sorry. Okay, I'm sorry for interrupting you. There's a lag in the video. I apologize. Please continue.
I'll take up your motion to vacate temporary orders, but we're not going to go into 960 pages of DFPS documentation when you have a final hearing set in this case, September the 1st. That's the purpose of that hearing. You understand?
I understand. I just want to call note to just 3 pages of that report.
Okay. All right.
Just three. My sons were adopted
Your Honor.
out prior to them having the legal authority to do so.
Your Honor,
And it's right there in their case notes. They ignored a phone call from my mother and they signed adoption paperwork on 9/4. Furthermore,
Your Honor.
Ms. Moore,
fur-
hold on, Ms.
Yes.
Gorham.
I just want it on the record that she is represented by an attorney, that I did not file these pleadings, and that she's proceeding against her attorney's advice.
my attorney does not speak
Okay,
to me.
duly noted, Ms. Moore, thank you.
Thank you.
And let's talk about your motion to withdraw at this point. You've got a motion to withdraw. Ms. Gorham has motions on file about your representation of her. Ms. Gorham,
Yes.
like I said, if you would like another attorney in this case, you are welcome to go find your own attorney, hire that attorney, and that attorney will file a substitution in this matter. And as soon as you're able to do that, I will substitute that attorney in for Ms. Moore.
Your Honor, I did hire an attorney for the de novo trial. And after one conversation with the district attorney, he decided not to represent me. And I did pay $10,000, which I have not been refunded on as of this day.
Okay, that's between you and that attorney, but certainly if you want to hire a different attorney, I'm happy to substitute that attorney in for Ms. Moore. Now, with that being said, Ms. Moore, I understand the dynamics here. The reason I'm not substituting another attorney off my list is because I don't believe Ms. Moore is the problem. Ms. Gorham, I think, is the issue, and I think any attorney on my list is going to have the same issue with Ms. Gorham, and I don't think substituting somebody in really solves any problems whatsoever. So I'm leaving. Basically what I'm doing, Ms. Moore, because I understand the predicament that you are in, I'm granting your motion to withdraw. So send me an order granting your motion to withdraw.
Yes, ma'am.
However, I'm ordering you to appear at each hearing. I'm ordering you to be available for Ms. Gorham if she changes her mind and wants you to represent her.
Yes,
I'm
ma'am.
ordering you to, basically, what I'm preventing is a delay in the proceedings so that we have to get another attorney in this case up to speed on things. So I'm ordering you to be present at each hearing that we have in this case, and we'll certainly give you notice of each hearing that we have in the future, and basically be on standby for Ms. Gorham
Yes.
when she starts making better decisions, hopefully, and decides like she did the last time she was
You guys
here
are a
to
joke.
listen to you, Ms. Moore.
This
Okay,
is a joke.
do all the parties understand my ruling with respect to Ms. Moore's representation of Ms. Gorham?
Yes, Your Honor.
Ms. Gorham, do you understand my ruling with respect to Ms. Moore's representation of you?
100%.
Okay, again, I'm going to say it again, just to be clear, she doesn't represent you anymore, but I am ordering her to appear at each hearing and to be available to you if you change your mind and want her to represent you going
So
forward.
therefore, I'm unrepresented? Isn't that against my constitutional right as well?
You're asking
I don't
me
have an attorney
to be
now?
unrepresented. Like I said, you are welcome to go hire any attorney you want to. And that person can appear.
I'm sorry, I appear in opposition of the suit. Therefore, it's your job to appoint me an attorney. Is that correct?
But you filed your own motion to fire your attorney.
Because she's not fighting for my rights.
So are you wanting to fire your attorney or not? You
Yes.
said both things in the last 2 minutes. Do you want Ms. Moore to represent you or not?
No, I do not. I
Okay,
would like a substitution of counsel.
then hire your own attorney. You have all the opportunity in the world to go hire anybody you want to in this matter. But again, Ms. Moore, I'm going to grant your motion to withdraw, but be available for Ms. Gorham to represent her if she changes her mind and wants to be represented by an attorney in this case going forward.
Yes, ma'am.
Okay, go ahead, Ms. Gorham. Call your first witness
Um,
on your motion to vacate temporary orders.
DFPS.
Which person?
Teresa Grimaldo.
She's not here.
Okay. Well, 8/5 following.
Did you subpoena her?
Yes, that would
Did you subpoena her?
Oh, no, I didn't. I'm sorry. I'm not an attorney. I'm just standing in my truth that I'm not a risk to my sons. Do I need to say that again? C14, she requested BID funding, which proves that, I mean, and that was on 8/5. That was one day after our
Ma'am, I have no
exception
idea what you're talking
into.
about. You need to
Of
call a
course
witness.
you don't, because you've been blindfolded by lies.
Call a witness. Do you want to testify yourself?
No, I mean, I don't have a witness, obviously. So I would like to testify. Can I call myself as a witness?
Yes, ma'am. Can I get you to raise your right hand?
Okay. Yes.
Do you solemnly swear that the testimony you're about to give me will be the truth, the whole truth, and nothing but the truth, so help you God?
So help me God, I do.
Okay, go ahead.
Page 196 of their 968 page case notes that was sent to me by Sarah Moore after she stated good luck going through them all. There is evidence of BID funding, and that happened on 8/5/2025. That is one day after her first home visit to my home when we were placed on alternative response due to a medical condition. Now, BID funding, I had to Google it. It is kidney transplant.
I'm gonna
Funding
object
from
to
Title
anything
4 or
that
5,
was
whichever it is.
obtained via Google.
I'm sorry. I'm being interrupted. I'm speaking right now. Okay.
Sustain.
So BID funding is for
Nope.
kidney transplant.
Ms. Gorham,
Not only does that show, like a motive for this whole debacle of a fake exigency, but it also shows that Teresa knew my medical condition for an entire month and refused to offer me services like a protective homemaker when I was during extreme medical duress for an entire month. She refused to offer me any services, yet she went and applied for funding without my knowledge or consent for herself or for, I don't know. And there's also on C12 on my list of exhibits. They signed foster care paperwork on 9/4. That's one day before they filed with court. There was a call from my mom on 9/4 that said she would take my children. So they ignored
I'm gonna
placement with my
object.
mother.
This has been adjudicated
yes, ma'am.
not only in
Yes.
your court.
Sustain. We've heard all of these facts. I heard all
No,
of these
you
facts.
haven't. I've been
I
involved
heard,
in.
Miss Gorham, do not argue with me, ma'am. I will find you in contempt.
Yes, Your Honor.
Your objection is sustained, Ms. Kidd. We heard all of these facts in an adversary hearing almost a year ago, and then Judge Eichmann heard the same facts in his court for the second time, and he made his ruling in his court. So we've already heard all of this, ma'am. So the objection is
I'm
sustained.
sorry. Can I please ask where was I whenever you heard all this? Because this is illegal.
We're in my
This
courtroom,
is not
ma'am.
legal. This is not legal. First of all, I didn't have a kidney transplant. Second of all, this was one day after my family's admission on an AR track. There's no perpetrator that's designated on an AR track. There is no investigation.
Ms. Gorham, do you have any evidence to present to the court whatsoever that I did not hear at your adversary hearing and that Judge Eichmann did not hear?
I believe all of this is my adversary testified, correct? Without an attorney at that, because Sarah Moore wasn't appointed my attorney until 5 hours after that hearing.
That's not correct, ma'am. Ms. Moore represented you in the adversary hearing.
Your appointment in your order for protection.
You're arguing with me, Ms. Gorham. Do you have
attorney.
anything else? Anything else? Otherwise, your motion to vacate is denied. Anything else that you want to present to the court?
The discovery of a mini lab in their
Right.
case notes.
Just-
That is not
Oh,
true.
gosh.
That is
What a mess.
falsification of a police report by Teresa Grimaldo.
All right. Does anybody else have anything else? Ms. Gorham's motions are all denied.
No,
Judge, if
Judge.
I may, I have one item. In preparation for today's hearing, and I recognize that it was 11th hour and late by the rules, but I would just ask for leave of court to file an objection to the summary judgment. I know that it has been denied. Simply on behalf of the department indicated that there obviously remained more than a mere scintilla of factual issues in this case, as evidenced by not only the case record, but the all of the various things filed by the mother. And I'd just like to have that on file with the court.
Sure. Leave to respond to respondent mother's motion for summary is granted.
Thank you, Your Honor. I think we had already, shortly before the hearing, emailed it out to yourself and the parties, but I will have it formally filed and sent to everyone via the e-file system as well. Thank you, Your Honor.
Yes, sir. Ms. Gorham, I don't know how to express to you this any other way. You really don't have any idea what you're doing practicing law. Nothing you're filing, nothing you're saying makes any sense in terms of legal procedure. I got so excited the last time that you were here when I heard you say that you were okay being represented by Ms. Moore and that you were going to listen to her advice and that you were going to start services in this case. You have now less than 2 months until your final hearing in this case, and all you're doing is filing ridiculously nonsensical pleadings in the case instead of doing your services.
I apologize for my ridiculous pleadings, as I don't know what I'm doing. All I'm trying to do is stand in the firm truth that I am not a risk to my sons, and I will not sign to services that I don't need, and I will not allow them to get away with this debauchery. It's all nonsense and it's lies.
Okay, Ms.
And if I need to go hire an attorney to prove it, then so be it.
Great.
And we'll see you in court in 2 months. You know what I mean?
Yes. You're welcome to hire an attorney to represent you at that final hearing, and you will have your opportunity to testify and call any witnesses you want to about this matter. You have full opportunity at that final hearing on September the 1st to present your case in front of Judge Eichmann. He will make a ruling as to conservatorship going forward of these children. So you're not being denied any right. You have a final hearing set, and the motions that we had set for today don't make any legal sense whatsoever. So they're all.
I haven't been denied rights, and my objection was for you. I mean, the objection was not for Judge Eichmann. It was for these issues to be heard with an associate judge, which would be you. That was the objection I filed, not for Judge Eichmann. You said it didn't make any sense. I was just clearing that up. But that's fine. You want to lead me into an merits trial without an attorney, unless I hire one? So be it.
Ms. Moore will be available for you. She'll be sitting right behind you in the final hearing.
Oh, and I'm sure she's done great wonders for my case. She's advocated seriously for my case. For her
to do so.
Thank you.
Moore will be right there. All right. Anything else that we need to take up today?
No, ma'am.
Okay, the final hearing is set in front of Judge Eichmann on September the 1st at 9 a.m. And for the record, Ms. Gorham left the hearing before I finished talking. Okay. Any issues with the children that we need to take up? Are the kids okay?
The kids are doing great, Your Honor. There's no issues with them whatsoever.
Okay. Mr. Morrow, any issues or concerns regarding the children?
No, Judge, not at all.
Casa, any concerns regarding the children?
No, Judge, they're doing great.
Okay. Does everybody understand? I want to make sure, Ms. Moore, that you understand my ruling with respect to your representation.
Yes, I do. Thank you, Your Honor.
Okay. I know it's an extremely delicate situation in terms of your responsibilities to your client and the rules of ethics in Texas for lawyers. Like I said, it's an extremely delicate situation. So I am going to grant the motion to withdraw, but order you to be present at every hearing, be available by telephone for Ms. Gorham if she wants to talk to you before the final hearing, be present at the final hearing in case Ms. Gorham decides that she wants to be represented by an attorney.
I'll be there.
Okay. Thank y'all. And
Thank you.
Miss Moore, in your order granting your withdrawal, will you put that language all in there? So that,
I will.
so that the written order that's part of the file reflects that entire ruling. It's a
In the
little bit
alternative,
different.
yes.
Yeah, it's a little bit different than a regular order granting withdrawal. So let's make sure all that language gets part of the order and part of the record.
Judge, do you
Yes,
want me
ma'am.
to do an
Thank you.
order denying all of Ms. Gorham's motions?
Yes. Yes.
Okay.
Okay. Anything else?
Lee, could you call me after this hearing's not related to this case, but a case that you and I are in the middle of a file hearing on, if you don't mind?
Yes, sir.
Thank you.